bridge trust is an asset protection trust which combines the simplicity of a domestic trust with the superior protection of a foreign asset protection trust. Foreign asset protection trusts, FAPTs, were first created in the Cook Islands by the Cook Islands Trust Act in 1984, and in the more than 30 years since their inception have proven to be extremely effective in their ability to protect client assets in a crisis. Domestic asset protection trusts, DAPTs, were first created in Alaska in 1998. They modeled the foreign statutes in an attempt to create a similar level of protection. However, because every state must recognize the laws and judicial proceedings of every other state under the U.S. Constitution and the overriding power of the federal courts, the domestic APTs have proven to be much less protective and certainly less predictable. The bottom line is that the foreign trust is more protective, but also comes with more costs, restrictions, and compliance requirements. The domestic trust is simpler to set up and maintain, but has what I consider the fatal flaw of potentially not working at all. The bridge trust combines the strength of a fully foreign trust and yet is simpler to set up and simpler to maintain than even a domestic asset protection trust. Over the past 20 years that we've been using the bridge trust, I've identified 6 reasons why I consider the bridge trust to be better in almost every case than a standalone foreign or domestic asset protection trust. Reason 1: strategy versus tactics. Strategy is the big picture plan that is driven by your overall goal, and the best strategy is defined by creating lots of options. Tactics are the skills, maneuvers, and tools used to accomplish the goals defined by the strategy. The bridge trust is designed strategically with the goal of protecting your assets. It creates multiple options to do so, one of which is to become a fully foreign asset protection trust. The foreign trust itself is a tactical maneuver that may or may not be the best move in any particular situation. The bridge trust creates options and is supremely strategic in nature, while the foreign trust is a powerful tactical tool when used appropriately. It is rarely wise to begin with tactics, which is why beginning with a foreign trust not only limits your options, but at times can put you at a significant strategic disadvantage, as we'll see. Reason number 2: optics. Optics refers to how things appear in the eyes of a judge or jury. Good optics means that your case feels right, your arguments and actions make sense, and nothing feels fishy or raises red flags. They improve your negotiating position, and you're more likely to find favor with the court, and this creates more settlement leverage in your direction. Bad optics are when the actions and facts appear devious or fraudulent, or meant to distract or hinder. In other words, they raise red flags. Bad optics are more likely to find an unsympathetic court, and thus diminish your leverage and negotiating position. And like it or not, in today's world of Panama Papers and headline news of hidden bank accounts, the word offshore automatically creates bad optics, so use with caution. Reason number 3: flexibility. A flexible asset protection structure gives you options, and options are what you need most when facing a crisis. One of those options is for your bridge trust to become a fully foreign asset protection trust. For example, when you've exhausted your domestic defenses and doing so doesn't damage your optics. However, in many cases, the domestic defenses are strong enough, and it would be a strategic disadvantage for you to be forced to disclose to the court any offshore entities or accounts. In this case, triggering the foreign component of your bridge trust would be a tactical failure. By creating the bridge trust, you give yourself the option to legally and ethically move your assets offshore in the event that this is a tactical advantage, but not the obligation to do so. With a foreign trust, you've reduced your options to just one, and if that turns out not to be the best one, you're stuck. Reason number 4: control. Asset protection works in large part by removing you from control of your assets. But you would always want control of your assets if given a choice. The bridge trust gives you that choice. When the plan is created, the trust is on the domestic side of the bridge, and you have full control as trustee. Only if the trust comes under duress does control pass to the foreign trustee. This, combined with the dropping of the U.S. jurisdiction and moving fully to a foreign asset protection trust, provides the effective protection for trust assets when it's needed. Reason number 5, cost. Everyone is concerned about cost, and there are two components. Number 1 is the acquisition or setup fees, and number 2 is the ongoing maintenance expenses. Setup fees vary widely depending on the law firm, the client, and the jurisdiction. However, it's safe to say that offshore planning is consistently more expensive to initiate than a domestic structure. Foreign plans typically run from $25,000 to $50,000 or more, while plans which don't include a foreign component are typically under $25,000. Maintenance expenses also vary, but again, offshore maintenance is consistently more expensive. I advise clients to budget between $5,000 and $10,000 a year to maintain an offshore structure. This may be cut in half with a domestic-only approach. The bridge trust is less than $25,000 to set up and has a fixed annual maintenance fee of $2,100 per year. And it normally does not require a tax return or any other U.S. filing requirements. This simplicity of maintenance, combined with a fixed and reasonable annual fee, creates long-term sustainability of your plan. And having your planning in place when you actually need it is why you set it up in the first place. Reason number 6, compliance. None of my clients like filing IRS forms, and they like paying extra expenses even less. Foreign trusts have a specific compliance burden. They must file Form 3520 and Form 3520A each year. These forms are full balance sheet disclosures and are extensive, requiring a listing of all the parties involved, trust assets, and terms, and may even include a full copy of the trust itself. Not only does this create additional fees, but it limits the future flexibility of the planning. Given a choice, I would recommend avoiding any IRS filing requirements which aren't absolutely necessary. Because the bridge trust begins life as a domestic grantor trust, it's not required to file Form 3520. And in fact, is not required to file a tax return or even get a tax ID number. This tax simplicity, combined with the ability for you to serve as your own trustee, is what makes the bridge trust truly unique. I believe that the bridge trust is almost always a better planning vehicle than either a fully domestic or fully foreign asset protection trust. There are, however, 3 questions that I hear most often. Question number 1, can a court in the U.S. invalidate the bridge trust? Well, the answer, of course, is yes. But this is also true for a fully foreign trust or a fully domestic asset protection trust. There's simply no way to ensure what a U.S. court is or is not going to do. The real question is, what would be the impact? If good strategy has triggered the bridge trust into a foreign trust, then a U.S. court invalidating it would make virtually no difference to the effectiveness of the trust. For all the same reasons that the fully foreign APT is going to withstand a U.S. court challenge, so will a triggered bridge trust. Question number 2. Does waiting until after the threat has materialized to cross the bridge create a fraudulent conveyance? This is a very popular question and really stems from a misunderstanding of how fraudulent conveyance works. The answer is no, it doesn't. The conveyance occurs when the plan is created and the trust is initially funded, not when any particular trust asset or even the trust itself crosses the bridge. Again, once the trust becomes a fully foreign trust, any challenge to this would have to be heard in the High Court of the Cook Islands. Question number 3. Can my assets get stuck in the U.S. or frozen before I can move them? I have never seen this occur. Legal cases take years to unfold and develop. If triggering the bridge trust into the Foreign Asset Protection Trust is the right strategic move to make, the inherent delays in the U.S. legal system provide more than enough time. The idea that the average plaintiff can run into a court and convince a judge to freeze all of your assets before trial is simply unfounded. The takeaway: asset protection can be one of the most liberating steps you can take to increase your confidence in your financial future. For most of my clients, the flexibility of the bridge trust strikes the right balance between the mitigation of the risks, the costs, the control, the compliance, and the ultimate effectiveness of the planning. To find out if the bridge trust is right for you, schedule an analysis today. Remember, it's your money. Act like it.